This, and I'm really looking forward to hearing more too about the work that your working group is doing, particularly around human rights and climate change as well. The Netherlands has long been a site that the international communities look to for action on climate change. So it's really great to sort of be in conversation and learn about what you're doing. Before starting too, I want to acknowledge that I'm speaking to you from the lands of the Wurundjeri peoples of the Kulin Nation, who are the traditional owners of the land on which I live and work in Melbourne. And I think this acknowledgement of country is especially important when we're talking about climate justice, because we know that Indigenous people are both at the forefront of climate impacts and at the forefront of many environmental struggles, especially against the expansion of fossil fuel extraction and the construction of new fossil fuel infrastructure. Further, this acknowledgement is especially important when we're talking about pedagogy, because I strongly believe that a commitment to making legal education more climate conscious needs to be accompanied by a commitment to decolonise our curriculum. So I want to talk to you today about a pedagogical project that I'm currently leading together with my colleagues, Professor Nicole Graham from the University of Sydney and Ms Zoe Ney from the University of Melbourne. And I also want to acknowledge the generous support of the Victorian Legal Services Board, whose grant program has enabled us to do this work. And whilst a lot of my presentation is obviously focused on Australia and the work that we're doing here, I very much hope that that is useful for sort of similar challenges and questions that you're engaging with in the Netherlands. So a bit of an overview of our project in a nutshell, and I'll talk through each of these aspects in more detail. So the challenge, as I see it, is that climate change related risks, impacts, responses and disputes already are transforming all areas of legal knowledge and practice. And thus we need to appropriately support and resource legal professionals to navigate this changing legal landscape and to advance climate change mitigation and adaptation. And thus our objective is to transform legal education, to produce more climate conscious legal professionals with the skills and the knowledge to be thoughtful, strategic and successful advocates in a climate transformed world. And so in order to do that, we've undertaken a couple of different project activities, sort of mapping the existing pedagogical practices, because we didn't really know what individual teachers were doing and to what extent they were already doing some of this work. Developing educational resources, particularly an open access textbook that will address all areas of the core law curriculum in Australia and address how climate change is relevant to all these different areas of law, and establishing a community of practice of climate conscious legal educators to share experiences and skills. So a little bit more about sort of the background challenge. As we know, climate change impacts and the transition to a low carbon society pose fundamental challenges to key legal doctrines and principles, and are already leading to the transformation of many areas of law. So addressing the impacts of climate change and ensuring that the transition to a low carbon society is just and equitable also requires changes to key legal doctrines and principles. And this widespread legal change necessarily extends beyond the sort of specialised field of climate or environmental law and implicates all areas of law and legal practice. So I've taught and established a subject called climate law at my university, but increasingly I'm finding that we're seeing climate change come up in all these other areas of law, company law, trust law, tort law, that I'm not a specialist in. And that's why we really need the specialists in those areas to be engaging with how climate change is relevant to those areas of law when they're teaching that in the classroom. And so we can see, firstly, I think some of the things that we need to think about in terms of being more climate conscious is how legal doctrines or areas of law might have contributed to climate change and its underlying inequalities. And there we can think about how law has authorised and enabled the lock-in of fossil fuel economy. And there in particular, we can recognise that property law, licensing regimes, company law, etc., is particularly implicated in sort of bringing about the current crisis that we're in. We can also think about how certain areas of law and legal competencies might help us address climate change. And there in particular, we're seeing the growth in climate litigation being increasingly creative about the different causes of action that are being mobilised to drive legal responses to climate mitigation and adaptation. And we also might think about how certain legal doctrines might be impacted by climate change or the transition to a low carbon society, that we might need to reconfigure particular areas of law, insurance law, financing provisions, and plenty of others. So this means that lawyers increasingly have an obligation to adopt what we call a climate conscious rather than a climate blind approach to daily legal practice. As the Chief Justice of the New South Wales Land Environment Court, Justice Brian Preston has argued, and I quote, "A climate conscious approach requires an active awareness of the reality of climate change and how it interacts with daily legal problems. The need for legal practice to become more climate conscious has been highlighted by a number of legal bodies in the US, in Australia, and elsewhere." So I've got there on the slide sort of a statement from the International Bar Association. They put out a climate crisis statement. Oops, I skipped. The American Bar Association, I've included there a quote from their 2015 memorandum. However, this was followed also by a resolution in 2019, which urged federal, state, local, territorial, and tribal governments and the private sector to recognise their obligation to address climate change and take action to reduce US greenhouse gas emissions to net zero below as soon as possible, consistent with the latest peer review science. And also urges lawyers to engage in pro bono activities to address climate change, and urges them to advise their clients about the risks and opportunities in addressing climate change. In Australia, we're seeing similar statements in the Law Council of Australia's climate change background paper from 2021 and their policy statement. So they recognise there too that novel, complex questions of law are arising and are likely to arise across multiple legal practice areas. We also had the World Lawyers Pledge on Climate Action a couple of years ago, which was signed by over 650 lawyers and legal professionals, which calls on lawyers of all kinds, not just environmental and climate lawyers, to consider, integrate, and apply issues of climate change and climate justice within and throughout their respective areas of activity and expertise. And so law can play a crucial role in mitigating and adapting to the impacts of climate change. The recent IPCC assessment report included the warning that climate change is a threat to human well-being and planetary health, and any further delay in concerted anticipatory global action on adaptation and mitigation will miss a brief and rapidly closing window of opportunity to secure a livable and sustainable future for all. Considering these sort of dire warnings, it's not surprising that we've seen a real explosion of climate litigation since the Paris Agreement. And so I've got some figures there from the 2023 climate litigation report from the UNEP. They documented 2,180 climate litigation cases globally. Most of those were in the US, but all around the world. And whilst we saw the so-called first generation of climate litigation primarily relied upon traditional environmental law methods of seeking administrative or judicial review of government decisions, the second generation of climate litigation has become increasingly innovative, raising an increasingly broad causes of action, including public trust, human rights arguments, corporate law duties, fiduciary duties, consumer law, greenwashing arguments, torts, and many more. And while the first generation was primarily against government actors seeking a review of government decision making, these cases are now being brought against a wide range of public and private actors. As well as driving climate change, lawyers and legal professionals have a broader obligation to consider systematically how law will influence the way in which society experiences and responds to climate change. And central to this is recognising the key role that law plays in society in allocating risk, liability, cost, and responsibility. And also these questions about how we equitably distribute risks. And so there's increasing recognition and awareness about climate risks. And here I take the definition proposed in the Task Force on Climate-Related Financial Disclosures from 2017, which divided climate risks into transition risks and risks related to the physical impacts of climate change. And so these questions of risks arise in lots of areas of law, whether in contract disputes or in company law, about what risks company directors need to manage, fiduciary obligations, or even a lawyer's professional obligations to advise a client about relevant risks. And so increasingly we're seeing this question about how does climate risk need to be engaged with as a material risk in all these different areas of law. And finally, for me, this is the most important aspect. Because climate change reflects and reproduces existing inequalities and vulnerabilities, it's also unavoidably an issue of equity and fairness. So climate vulnerabilities intersect with and reproduce and intensify existing marginalisations. In terms of race, gender, age, we know that children and the elderly are most vulnerable to the impacts of climate change, in terms of disability and many more sort of categories. And thus, there's strong demands for climate justice, which entails, as we know, distributive justice, procedural justice, recognition justice, and reparative or corrective justice. And I would therefore stress being a climate conscious lawyer also requires lawyers to be conscious of these intersecting justice issues raised by the impacts of climate change and or the transition to a low carbon society. So to recap, we argue that all lawyers increasingly need to be climate conscious lawyers. And we suggest this entails engaging with the question of how might climate change impact different areas of law, how might different areas of law contribute to climate change and its underlying inequalities, and how might different areas of law and legal competencies help us address climate change. But obviously, if we want lawyers to be climate conscious, we also need to transform legal education to produce more climate conscious legal professionals with the skills and knowledge to be thoughtful and strategic advocates in a climate transformed world. And so, as recommended by the United Nations and numerous legal organisations around the world, many legal educators are beginning to incorporate climate change related case law, legislation and policy documents, learning materials, and or assessments in both core and elective curricula of undergraduate and graduate law programs. And there's a number of reasons why this sort of pedagogical transformation, I think, is really necessary and also unavoidable. Firstly, it's addressing student demand. There's growing demand from students for climate conscious legal education. Law students see the scale of the climate challenge and are signalling that they want to be part of the solution. A 2019 global survey of 10,000 young people aged 18 to 25 found that climate change ranked first as their most important global issue. And secondly, social justice and addressing a social need. So current law students, I often say, will be leaders of the profession at the middle of the century when the global community is committed to reaching net zero emissions. So it's crucial that this generation of law graduates and lawyers is then provided with the training and support to be climate literate and climate conscious legal practitioners. And finally, one of the risks that's often discussed in relation to climate change is the risk of assets becoming stranded. So stranded assets being assets that suffer unanticipated or premature write-offs, devaluations, or conversions to liabilities due to climate change or climate-related impacts. And the focus has understandably really been on fossil fuel reserves becoming stranded assets if laws would actually be put in place that would prevent them from being extracted. But increasingly, it's worth considering whether degrees that don't equip students for a climate transformed world might themselves become a stranded asset. So we say that we do need to mainstream climate change across legal education, and this can be done in different ways. There are a number of different approaches to mainstreaming. Firstly, you can have a more incidental approach, which is sort of informal discussion with students about legal development or case law related to climate change in the unit content. On sort of like a higher sort of level of engagement, you could have what we call an embedding approach, which might formally incorporate climate change as part of the units of curriculum in the case list, the reading lists, etc. And this could be done on a unit by unit basis or more systematically across a degree. Or then what we call sort of centering, which would be formally incorporating climate change considerations as a learning outcome at the course level or at the subject level, and then have assessment tasks that are assessing students on the development of climate change related knowledge, or competencies or skills. And so that's a much more sort of deeper level of mainstreaming. So in Australia, law is a professionally accredited degree. I'm not sure if that's the same in the Netherlands, but in Australia, in order to be eligible for admission as a legal practitioner, you need to have completed a professionally accredited law degree, as well as practical legal training, and then demonstrate that you're a fit and proper person to be a legal practitioner. And then in order to be a professionally accredited degree, every law degree needs to teach a number of prescribed knowledge areas, which are sort of colloquially referred to as the Priestley 11. And these are the core compulsory subjects in every law degree in Australia: administrative law, civil dispute resolution, company law, contracts, criminal law and procedure, ethics and professional responsibilities, equities, evidence, federal and state constitutional law, property, and tort law. So as I said, I'm not sure if it's the same in the Netherlands. Like I know in America, they don't have this sort of prescribed list, but they have the bar exam. But I think in most jurisdictions, you do have a set of core subjects that are seen as central to legal practice, that even if they're not compulsory, are generally taken by most students as part of their law degree. And so we've really decided to focus on these areas of law because it seems like by embedding climate change in those areas, you sort of have the greatest impact. And just to give you like a little flavor of that we are struck by how climate change is relevant across all these other areas, as well as all the sort of popular elective areas as well. So just as a little flavor of that, criminal law, for example, there's sort of, more hypothetical questions about whether fossil fuel companies could be charged with homicide or other crimes. But there's also the way in which criminal law is engaging with climate protests, defence of necessity being raised, bail being denied as forms of quasi-injunctive relief against protesters. And I think sort of engaging with these sort of questions then also opens up a much broader discussion about the purpose, functions, and biases of criminal law. When I was in the Netherlands recently, people were telling me about cases concerning the soups being thrown at paintings, sort of engaging questions of rights and protests, etc. as well. So, there's clearly a lot of discussion in this space. We see criminal law, both not being applied in cases where we might think it might better be applied, and then being, deployed to prevent climate action. And tort law, again, really obvious examples. In the US, we've got ongoing tort litigation by various communities, particular fishing communities, against the fossil fuel majors. In the German courts, we've got the Korean farmer suing the energy giant RWE. In Australia, we had a case where young people argued the government had owed them a duty of care when making a decision to approve new coal mines, which then went through the principles of what a duty of care is. And so there's various doctrinal hurdles facing climate change plaintiffs. But as Douglas Kaiser identified over a decade ago, the reverse question is often not posed: what can climate change do for tort law? And suggests that climate change could force courts to confront questions of harm, causation, and responsibility that really lie at the frontiers of science and ethics. So engaging with these sort of questions of climate change could be really transformative for these areas of law as he identifies. Company law, again, we're seeing massive developments in this area of law. In Australia, we've had litigation, Abrahams and Commonwealth, of a shareholder taking a bank to court regarding disclosures of climate risks. It's settled, so we don't have a court precedent, but the bank again made commitments that they would disclose and manage those sort of risks in the future. Across multiple jurisdictions, there's legislation requiring disclosure, etc., and a lot of shareholder activism around climate change. Contract law is one of the areas that's not so immediately apparent, but there's a growing movement by practitioners to incorporate what they call climate-conscious contractual clauses, with some of this work being spearheaded by the Chaucery Lane project in the UK, Australia, and elsewhere. And obviously in contract law, there's all those questions about the distribution and allocation of risks, also whether climate impacts could constitute a force majeure event that might lead to the breach of a contract, etc. And in areas of professional responsibility, you have the Law Society in the UK put out guidance on climate change and professional obligations. In New South Wales, the Law Society there has followed suit. And we also have students being increasingly vocal on these sort of questions, with Law Students for Climate Accountability developing a scorecard to rank top law firms based on how much fossil fuel work they do. And sort of increasingly, this question, is it time for lawyers to dump their fossil fuel clients, coming up as a question of legal professional responsibility. So, in the interest of time, I can't go through all the subjects, but I hope that's sort of given a flavour of how we're really seeing climate change impacting in all these different areas of law, often in ways that sort of go beyond sort of my um, knowledge as sort of a more climate focused lawyers to sort of really understand these different intersections in all these different areas. And obviously, I'm sure you'd all have plenty of examples from your own jurisdiction and areas of expertise. So, just a brief note on the questions of eco anxiety, because this is one of the things I was asked to address. And we know that it's likely that legal professionals, law students, and legal academics engaging with and working on climate change related issues will experience climate anxiety. And it's vital to support the emotional well-being and psychological resilience of legal professionals, law students, and law academics. And due to the time lag between the emissions of greenhouse gas emissions into the atmosphere and the manifestation of climate change impacts, many of the negative impacts of climate change will primarily and disproportionately affect young people and unborn future generations. And so we've got this growing body of evidence linking pressing issues of climate change to feelings of anxiety, despair, powerlessness, and anger in young people in particular. And a perceived lack of governmental action to adequately respond to the climate change crisis is associated with increased distress. In this sense, the phenomenon of climate anxiety is often rooted in the realities of what it means to live in a climate transformed world and the uncertainties about the future. And so I think this is something that as legal educators, we need to be increasingly aware of, that when we're talking about these issues, that it's very real for students. In a piece that I wrote with colleagues a few years ago, we looked at a sort of interdisciplinary agenda for climate change. Based on our own teaching and pedagogical experience, this question of eco-anxiety came up, and really recognising that many of our students may have first-hand experience of climate impacts in Australia, the Black Summer fires of 2019, 2020, but also recognising that many of the students in our classrooms are international students and they have their own experiences, or families have had their own experiences of climate change. So to recognise that we're talking about first-hand experiences for many people, as well as sort of this risk and fear and anxiety about what we know, the increased frequency and severity of climate impacts. And so for law students who are learning about the role of law in regulating, redressing, and even contributing to the climate crisis, this experience of climate anxiety might be particularly pronounced. And on the one hand, to effectively respond to the crisis, law students need to understand the challenges posed by climate change, as well as the systemic inequalities underpinning its causes and distributional impacts. However, it's equally important to equip students with the knowledge and skills to respond to the climate crisis and to work towards a more climate just future. So in the first decades of the 21st century, we've seen a proliferation of youth-led climate activism, litigation, and political engagement, demonstrating that young people are not only affected by climate change, but are also active agents of change. These youth-led movements and legal interventions can serve as a form of disruptive dissent, through which young people seek to transform norms, rules, regulations, institutions. And equally, these forums can empower young climate activists and amplify historically marginalised voices. Thus, when equipped with resources, not only for understanding the law, but also managing climate impacts, law students have the potential to meaningfully contribute to sustainable climate action. So I think it's this sort of tough balance between recognising that this climate anxiety is real, but then also giving students a sense of empowerment, that they can make a difference with the skills and the knowledge that they have. Because I think that it's a sense of powerlessness that's particularly difficult in dealing with climate anxiety. And I think the more we can do to make our students feel empowered that they can contribute towards bringing about some sort of change. I always sort of say that, action is the antidote to despair, that is incredibly powerful. So when teaching a climate law subject, for example, I found students got really depressed when we talked about, the limitations of the existing legal regimes, but then ending on climate litigation and sort of hearing from some of the litigators sort of allowed them to sort of be more optimistic about what the possibilities that law could contribute. And one of my favorite pedagogical stories is the first time I taught the climate law subject, I invited David Barnum, who's an amazing climate litigator, to come talk to the class. And then after the class, he started talking to one of the students. And then about a year later, I read in the newspaper that she'd brought an action suing the government for their failure to disclose and manage the climate risks in climate bonds. I mean, in the government issued bonds. So again, things like that sort of give you a sense about how do we empower students as well. And I think that's sort of one of the things that we're really trying to do with this textbook as well, which I'll talk about in a minute, is give students a sense of you can develop the skills to do something about these issues. So one sec. And then the other thing that we've done is sort of try to understand the extent to which climate change, now I've lost my notes, is being already taught. That we know in Australia there are 2 law degrees at Bond University and also at Queensland University of Technology that they've taken an institutional approach to wanting to bring climate change into the curriculum. But at many other institutions, it's sort of individual activities by individual academics to sort of bring in climate considerations into the classroom, not really institutionally supported. And we didn't really have a sense of the extent to which that was happening. So one of the things that we tried to do was do a survey, which we ran in October last year. We sent that survey, we had ethics approval from La Trobe University to do so. We sent an invite to participate in the survey to all law academics in Australia. It's about, that's about 1,400 people. And we got about 160 responses. So about 12% of people that we invited responded. And we think there's obviously a little bit of, the selection bias, in that the people who responded are the people who are most likely to be already engaging with climate change in their teaching. But nonetheless, we found it really valuable to have a sense of some baseline data, and also, again, some baseline data against which we can track the extent to which we're succeeding and expanding this mainstreaming in the future. And we can see here that the legal educators that responded to the survey taught a wide range of subjects, both the core subjects as well as popular electives. And the survey results suggested that climate change is already being considered and discussed in many core curriculum subjects in Australian law schools. Again, as I said, there's clearly a selection bias. However, the survey demonstrated a relatively high proportion of legal educators are incorporating climate change related content, particularly in the teaching of company law, torts, professional responsibilities, constitutional and property law. The survey also revealed that climate change considerations are more likely to be incorporated in the teaching of elective subjects, not only the obvious subjects of environmental and international law, but also in human rights law, tax law, legal theory, and many others. And while the majority of law school academics emphasise their support for incorporating climate change considerations in teaching practices, there are individual and institutional factors that limit current capabilities. Firstly, the respondents emphasised their perceived knowledge gaps about climate change science and climate change law. A lot of people felt they didn't have sufficient expertise to do this sort of teaching and work. Secondly, and relatedly, the respondents highlighted uncertainties about how best to integrate climate change in the existing curriculum. And finally, respondents underscored the lack of time and space in the curriculum to add additional material as a factor that limits current capabilities. So a lot of people said that the curriculum's already so crammed, we've got so much stuff we already need to get through, we don't have time to put something else in. So to address some of these barriers, survey respondents also identified 3 key interventions that could support legal educators to mainstream climate change in core subjects. First, the respondents stressed the need for resources such as textbooks or chapters to assist legal educators. Secondly, the respondents suggested that there's a need for accessible and updated online resources on the fast evolving developments in law related to climate change. And thirdly, the respondents pointed to the value of developing a community of practice with the purpose of sharing teaching resources and organising events focused on mainstreaming climate change considerations in legal education. And for that reason, one of our core project activities, which I'm really excited about, has been developing a textbook to provide resources for the integration and mainstreaming of climate considerations across the Australian legal curriculum. And so the textbook now includes 21 different chapters written by over 30 leading experts from Australian law schools. It covers all of those 11 compulsory subjects that I mentioned, as well as a number of popular electives. And we're publishing it in 3 different tranches. So the first tranche should be out sometime this month. I'm really excited to say it only has 3 chapters, unfortunately, but our next tranche will be much bigger. We'll hope it comes out at the beginning of next year so that it can be used in semester 1 teaching, which will have hopefully the remaining compulsory subjects, and then the 3rd tranche published in April next year will have the remaining elective subjects. And again, these are all, law is a jurisdiction specific discipline, but we hope that, people in other jurisdictions get inspired by this sort of work and might want to do something similar. One of the things that we were really attentive to is these questions of climate anxiety, as I said, and so we've got a section in an introduction that discusses that and provides a link to lots of resources that have been created by professionals. Because I do think it's also important for us to recognise that we are not psychological professionals, that we can't provide those sort of counselling services to students. And one of the things I've been trying to do is sort of push the counselling services at our universities to take these issues more seriously and provide those sort of services to students because they are much better equipped than we are to do so. But the other thing that we've done is that the first substantive chapter in the book will be on Indigenous peoples and the law to sort of, again, really foreground that commitment that making legal education more climate conscious needs to be accompanied by an engagement with Indigenous law, Indigenous sovereignty, and commitment to decolonise the curriculum. And it was really exciting in a recent workshop that we had with authors is that many of the different chapters were sort of engaging with these questions of Indigenous rights in their individual chapters as well. So it's both got its own chapter, but it's also themed throughout the book as a whole. And this book will be published open access by the La Trobe eBureau, which means that it's available to everyone free of charge. It also, one of the things I'm really excited about this online open access publishing model is that it makes it much easier to update than a sort of conventional textbook. You can update sections or chapters as the law evolves, because we're really conscious that the law changes really quickly in this area. So, for example, some chapters that we had out to review last year, we had cases being handed down in that period that they're in a review, and then the authors had to obviously update and modify based on that. But the online version also means that you can embed much more multimedia and images and things, which I think also are crucial for learning in this area, that it's really inspiring for students to hear from, particularly from lawyers and litigants involved in climate litigation cases, for example, and sort of to embed that sort of material as part of the pedagogy as well. So that sort of concludes my general presentation, but I'm really looking forward to discussion. But I hope that sort of conveyed why we think that mainstreaming climate change in legal education is really crucial and why we really think now is the time to do this. And I look forward to hearing about sort of similar efforts that you're doing in the Netherlands, or, sharing any ideas or resources and ways that we can learn from one another in doing this work.